Bismillahirrahmanirrahim. Assalamu alaikum, everyone. I hope that you're all safe and well. I hope that you all had a lovely Eid with your family and friends. We had quite a busy Eid weekend. One of the reasons why my video is a bit late today, because we had some friends over yesterday for a very nice meal, and it's taken me a few hours to do research for the topic today, which I'm sure you'll be actually quite pleased to hear that today I am talking about the testimony of women, particularly the point about whether a woman's testimony is worth half of a man's. This is something we hear quite often. I get this question a lot through comments on my channel. People ask me, is women's testimony worth half of a man's? It is said that this is based on a verse in Surah Al-Baqarah, verse 282. And very frequently, this is presented as a blunt and firm and simplistic opinion that a woman's testimony is worth half of a man's. I mean, it's very difficult to even quantify, understand what that means, but this is how it is discussed in popular discourse. But I want to share with you that there is actually a lot of in-depth discussion on this topic in our own fiqh literature, our juristic literature. So in today's video, I'm going to cover three things primarily. I'm going to share with you the opinions of some jurists from medieval times who were writing about 800, 900 years ago, and they grappled with this verse. Many of them found this verse to be in tension with the overall egalitarian vision of the Qur'an as well. So I'll share with you how they were dealing with, on one hand, restricting women's ability to act as witnesses, but then also allowing women to act as witnesses in other situations. So you'll spot some inconsistency, which I think also implicitly holds this tension, because the Quran, of course, treats women as fully autonomous human beings and gives them full legal agency. But I'll share the jurist opinions with you and some of the reasoning that they have employed. I will also, as I share these opinions, identify for you different types of witnessing and different types of witness reports as well, just to bring some clarity to this topic. And then I'm going to conclude by sharing my understanding of this verse and the overall narrative in the Quran within which this verse is found. So the internal narrative context of the Quran is very important in making sense of this verse and what it is that is being recommended here. For this video, I am primarily relying on a journal article by Professor Muhammad Fadil. I believe he wrote it in 1997. The title of the paper is Two Women, One Man: Knowledge, Power, and Gender in Medieval Sunni Legal Thought. You can find this very easily. If you Google this, I'll include a link in the video description as well. You can find this on the internet and you can read the paper yourself, but I will be picking out some key points from that. And then also, I'm going to very briefly rely on Professor Sadia Sheikh's essay, which is titled Islamic Law, Sufism, and Gender, Rethinking the Terms of the Debate. And in this essay, she refers to the opinions of the famous Sufi scholar Ibn Arabi, particularly his views regarding the testimony of women, but also in the essay, which you might want to read, he also talks about women being prophets, and he talks about the imamate of women as well, whether women can act as imams in a congregational prayer or not. I'm not going to delve into that. My focus today is on testimony of women. Now, a quick disclaimer before I delve into this more fully. I have used the phrase Sunni legal thought. That does not mean that I'm taking a sectarian stance. I don't take sectarian stances. I try not to take sectarian stances. Rather, I'm referring to the methodologies which, as we know, have been applied by the main Sunni schools of thought, legal schools, like the Hanafi, Maliki, Shafi'i, and Hanbali school. I'm not going to go through all of those schools today. But there are generally, in Professor Fadil's paper, Hanafi scholars are discussed throughout. And then there are also a couple of examples of Hanbali scholars' opinions as well. So this is what I mean when I say Sunni legal schools, not Sunnism as kind of a sectarian view, if that makes sense. I will not bore you with details of methodology. Again, that's not a concern today. Really, what is important is for us to understand the nuance in scholarly opinion, and particularly how they were grappling with this issue of women's testimony. So fasten your seatbelts. This is going to be a very interesting one. Now, we often hear that women's testimony is half of the testimony of men, and there's an excerpt from Surah Al-Baqarah that I will read now just to focus your mind. I will, of course, read the full verses later on, but here is the excerpt which is quoted very often. Call upon two of your men to witness. If two men cannot be found, then one man and two women of your choice will witness. So if one of the women forgets, the other may remind her. So this is the recommendation that we find in Surah Al-Baqarah, verse 282. It's a much longer verse. I've just read an excerpt from that. Now, based on this verse, some scholars have made the point that a woman's word, her testimony, her ability to bear witness to truth is half of a man's. Now, you can't exactly, halve human beings. But what this means is that a woman's word is not given as much credibility. Now, scholars have given various reasons for this across the years and across the kind of the millennium of Islamic legal thinking and tafsir tradition. Many of these reasons are problematic. They are gender essentializing reasons. They would use biological reasons. You may have heard things like women are more forgetful than men, or that they are intellectually not as capable, or that childbirth and motherhood makes them more emotional. So a lot of generalizations are made about women's ability, and also, their physiology, how that's different from a man's, and how somehow that explains the fact that women are more forgetful. So that's kind of roughly how this argument develops, and that's how we receive us. And some scholars even then extrapolate a formula from this verse, so if you're going to have two men, instead of two men, you'll have four women as witnesses. So they always are doubling the number of female witnesses, which again is quite problematic because this is not what the Quran is saying at all. So, we'll come to that in a moment. But let's look at some of the key points from Professor Fadil's essay, where he's encapsulating the discussions and the depth of discussions in Sunni legal thought around this topic. And because he's interested in medieval scholars, most of the scholars are writing in kind of the 12th, 13th century, 14th century of Islam. There are a couple of modern scholars that I will quote as well. Again, he references them in his essay. And interestingly, the earliest scholars like Imam Tabari had completely different view of that. So let's look into that now. So our jurists, fuqaha, treated this verse very differently from how the mufassirin, or the exegetes of the Quran, have treated this verse. Now, I have talked about tafsir tradition briefly before in some of the videos I've done on the topic of qawwam. Do look them up. But you will find that mufassirin, even now, often read the Quran verse by verse and explain the Quran verse by verse. And Amin Abu Daud points out that this is an atomistic, or kind of like a broken down reading of the Quran. The late Dr. Fazl Rahman, who was a great scholar, Muslim scholar, he also pointed to this atomistic reading of the Quran, where you don't read the Quran as a coherent text, you don't look at the paragraph, the overall narrative, but you take one verse and you explain it, and then you take another verse and you explain it. So Mufassirin tended to use that methodology. And Mufassirin were very comfortable in saying that women were just prone to errors and that they were just forgetful. So, for example, Imam Fakhruddin Ar-Razi, who died in 1210, so early 13th century, he said that women's biology made them more susceptible to forgetfulness. And this idea is echoed again by Sayyid Qutb, who, as you know, is more recent. He's writing the 20th century, so not very long ago. And he said that women's psychology, especially motherhood, affected their ability to be objective. So they can't be reliable witnesses. So here is kind of that gender essentializing argument, but also, that women are just forgetful anyway, or intellectually not as robust as men are. But then also looking at women's biology, and because it's different from men's, using that as a reason to explain that women are more susceptible to forgetfulness, and then motherhood makes them emotional, and therefore they can't be objective. They're very subjective. So their feelings overcome their ability to tell the truth. Other scholars that Professor Fadl cites, he talks about Muhammad Abdu, who, as you know, is a very well-known reformist scholar. He's writing at the turn of the 20th century, and he challenged these arguments, which are based in biology and psychology. Instead, he brought some sociological reasons. So he basically said that women are just as capable as men in regard to remembering things. In terms of their intellectual capacity, women are just as capable. But women play different roles in society and they mainly stay at home. And this is why they can make mistakes about economic or commercial matters because they're not as involved. And so Muhammad Abdu is taking a slightly different stance here. So this is roughly where you would find the Mufassireen's views settling. Muslim jurists, on the other hand, are fuqaha, who are engaged in interpretation and legal reasoning. They used to take a much broader and cross-disciplinary view of these matters, okay? Because now you're looking at legal reasoning, you have to take quite a lot of different things into account, including things like practical considerations of giving a religious opinion, a legal opinion. Remember, a fatwa is a non-binding legal opinion. So jurists are giving these fatwa and they want the fatwa to have a sound methodology. And they do take practical considerations into account. They do look at, norms and customs in society, and they also look at implications for legal matters as well. So jurists approach this very differently from Mufassireen, okay? And again, I'm still basing this on Professor Fadil's paper, so I'm going to share the gist of his discussion with you now. The first thing to bear in mind is that jurists distinguished between testimony. The Arabic word for testimony or giving witness in court is shahada. And the other thing that what they distinguished it from was riwaya, okay, riwaya or narration. Okay, narration, for example, hadith is a riwaya or a riwayat. It is a narration. Our jurists distinguish between those two things, okay, and there is a reason for that, which I'll come to in a second. Firstly, when it comes to witnessing or shahada, a witness in court has a lot of political power. Okay, their testimony can lead to punishment or freedom of the plaintiff or the defendant. Their testimony can even lead to loss of life or limb. Their testimony can lead to financial losses, a fine being placed on somebody. So when somebody is witnessing in court, they have a lot of political power. Whereas when it comes to something like a riwaya or hadith tradition, then that report establishes a religious teaching or a norm, which is universal, but any implications of it will be in the hereafter. Generally, there are no immediate implications. Now, jurists were very acutely aware that many hadith reports were transmitted very reliably by women, and many Muslim women were also jurists themselves, and they engaged in legal reasoning. And it's really interesting if you look at when people critique the hadith tradition in terms of the chains of transmission, very, very few women actually lie about hadith. Women are usually very truthful about hadith narrations. And women were also engaged in legal reasoning. Great sahabiyat like Aisha, radiallahu anha, who's the wife of the Prophet, Darda, Atiyah, may Allah be pleased with all of them. They had a very high stature in the legal sciences and hadith sciences. Now, hadith is also a testimony about something Prophet Muhammad said or did, and it establishes a normative teaching. As I mentioned, that teaching is universal, applicable to all Muslims. So as such, these traditions carry a lot of weight. They require a commitment to truth from those who are transmitting these reports. But as I said, there's no immediate legal impact of a riwayat. You're not stood in court hearing testimony from a witness, and which will have an immediate impact on your circumstances. So a witness testimony in court creates immediate legal effect, and many jurists were not comfortable with giving that much political power to women. So we find many arguments from them to limit women's ability to give testimony, whilst at the same time respecting women's ability to transmit a hadith report or to engage in legal reasoning. So you can see the tension there. Because actually, if they took away women's authority to relay hadith, to teach hadith, or to engage in legal reasoning, they would in effect be diminishing the stature of, great sahabiyat like Aisha, like Darda, like Atiyah, like Prophet's wife Safiya and others, who were such great thinkers. And jurists were reluctant to do that. So they had to maintain this stature for the great Muslim women that they knew of, who were very learned Muslim women and scholars. But when it came to witness testimony in court, they also wanted to curtail the political power that women had. So this is how they go about it. Al-Qarafi, who's writing in the 13th century in Egypt, he notes that a witness has a lot of power in court. Now, two women are needed to witness something because it's to protect the male ego. Roughly, that's what he's saying. Because otherwise, the defendant or the plaintiff can reject a court's decision saying they do not want to comply on the basis of one woman's testimony. Okay, so he is saying that women are naqisatul aql, they are deficient or weak in intellect and reasoning, and it is highly probable that if there was one woman witness, then her testimony would be rejected. It's really interesting how he is protecting kind of the male ego here, and what it tells us is that men really struggled to see women in positions of authority or to put them in a position where their testimony or their word could have a direct impact on them. We then have a 15th century jurist writing in Syria. This is At-Tarablusi. He says that whilst both men and women can be equally truthful witnesses in court, it is better not to take testimony from women, because this would mean they would have to travel to the court, they would have to leave their house, and this can lead to social corruption. So according to him, women are prohibited from going out, and by making it a socially acceptable norm to bring women to court, society will basically encourage them to be out and about, and this will end up corrupting the society morally. So he seems to be taking this stance to discourage the participation of women in judicial matters. So there is this reluctance here to again put women in a position of authority over men, or to see women out and about in the public realm. What is really interesting in all of this is that scholars had no issues with calling women as expert witnesses. Now, an expert witness only states facts. So, for example, you can ask a nurse or a doctor to come in and they could discuss the nature of an injury or a wound. Let's say what the victim has been physically hurt. So they might give a factual account of what the wound was like. And our jurists had no issues with accepting expert witness testimony from women. But it is only when the testimony carried political weight that jurists had an issue with allowing women in. So this eventually led to a situation whereby women were often not allowed to become judges either, judges in courts of law, because the argument goes, if a woman cannot give testimony, then she also cannot listen to testimony as a judge. Okay, really interesting reasoning here. But there are exceptions. Now, Hanafi law allowed women to be judges in cases that allowed women to be witnesses as well, and particularly in private matters which concern women, like menstruation or childbirth or stillbirth, etc. And Imam Tabari, who died in the early 10th century, so he's kind of one of the earlier Imams, he actually allowed women to be judges in all the areas of law, including commercial law and personal law. So it seems that the earlier scholars were more open to this idea than the scholars of the medieval period that I've mentioned just now. And Professor Fadil astutely notes as well that none of these medieval scholars were making references to the verses in the Qur'an. I mean, as I've just cited their opinions to you, none of them, not Al-Qarafi, was not making any reference to the verse in the Qur'an. In fact, they were using primarily arguments from social concerns or using social reasons to restrict women's testimony. And I think this is because they were quite aware that the Quran gives full legal agency to women. They were quite aware of the stature of women as jurists, as muhaddithat, and they did not want to touch that. So they were really not disputing the Quran's overall guidance or egalitarian message, but then using sociological reasons to curtail women's ability to give testimony. Now, one of the best insights into the Quranic verses comes from Imam Ibn Taymiyyah and his student Imam Ibn Qayyim al-Jawziyah, both of whom they were humbly scholars. They both passed away in the 14th century, so they're writing about 700 years ago. And Professor Fadl actually brings quite a bit of detail about the reasoning, but I'm going to quickly sum it up. Both Imam Ibn Taymiyyah and Imam Ibn Qayyim, they pointed out that the Quranic verse is actually not about court testimony at all. I remember when I read this the first time around, it's about over 10, 11 years ago, it was like an aha moment for me. So I hope this is also an aha moment for you. They pointed out that the Quranic verse is not about court testimony. In fact, the Quranic verse is about finding credible and truthful people that you know who can witness a contract of debt. Now, the parties to the contract have choice on who they want to involve, right? Somebody from their neighborhood or somebody from their circle of friends, for example. But when a crime is committed, if God forbid, there is grievous assault or there is a murder or something like that, the witnesses are not chosen by the criminal. The witnesses are not chosen by the victim. The witnesses just happen to be there. And this is a really great distinction that they draw between different types of testimony and different types of witnessing. And they both also pointed out that if the Muslim jurists were happy to accept a riwayat or a hadith tradition or a riwayah, which is testimony about our beloved Prophet sallallahu alaihi wasallam, and that they were happy to consider women to have intellectual capability and probity and truthfulness on the basis of which they would accept the riwayah from them, then on what basis could they reject or reduce the weight of their testimony in court? It doesn't make sense, right? These two things don't align. And they both argued that for the imperatives of justice to be held up, that the judge should simply be allowed to choose the witness based on the witness's credibility and truthfulness, not gender. Having said all of that, Imam Ibn Qayyim was also of the view that it is better to have male witnesses simply because it is easier for them to travel and appear in court. Okay, so he does bring kind of that sociological reason in, but only as a practical consideration. So they make these two powerful points. One, let the judge decide who should be a witness. And witness is somebody who the judge is convinced is able to tell the truth. They're a credible person. And they're not a habitual liar, for example. And also that this has nothing to do with gender. And when a crime is committed, you can't choose who your witnesses are going to be. The Quranic verse is not about a crime being committed. The Quranic verse is actually about writing down a contract. It's about notarization of a contract. Okay, it's a contractual agreement it's talking about, where you do actually choose your own witnesses. I'm also now going to share with you the views of Ibn al-Arabi, who is a 20th century Sufi scholar, philosopher. I'm now going to turn to Sadia Sheikh's essay, and her essay is titled, hang on, I am referring to this collection of essays, Men in Charge, and Sadia's essay is titled Islamic Law, Sufism and Gender, Rethinking the Terms of the Debate. And I am reading from page 123, where Sadia quotes from Ibn Arabi, but also she points out that Ibn Arabi, it's really interesting that he gives due consideration to what makes for a good witness. And according to him, a good witness is somebody who has experience and knowledge of the particular situation, and they're able to understand the context of that particular situation as well. So let me just quote from her translation of Ibn Arabi. This is on page 123. Usually, a judge does not make a definite judgment except with the testimony of two men. Yet in some circumstances, the testimony of one woman equals that of two men. For example, the judge's acceptance of her testimony about menstrual cycles as it relates to the waiting period after divorce, iddah, or the husband accepting her statement about his paternity of the child, despite the uncertainty pertaining to such situations. Another example of this is the acceptance of her testimony that she is menstruating. So she occupies, in such situations, the position of two reliable male witnesses, just as the man occupies the position of two women in cases of testimony about debt. So Sadia Sheikh is then giving her views, and she says, and I quote, she says, here Ibn Arabi is alerting us that context and experience are principal considerations when determining gender-specific legal capacity. Such an approach suggests that legal rulings appearing to favor men may simply be responsive to the realities and pragmatics of the social arena. In other words, our jurists were trying to be very pragmatic and very practical about what was possible. You know, could women travel to court? Did women know enough about commerce, for example? Ibn Arabi, then Sadia continues, the weight of women's and men's respective testimonies is related to these experiential and knowledge bases. Such a reading of the law resists the notion that male testimony is inherently superior. Given the vast social and historical changes in gender relations, this approach demands a legal system that is responsive to the shifts in human gendered experiences. So far, then, I have shared this quick survey of how the discussions on women's testimony took place in tafsir and fiqh sciences, and also in the views of a Sufi scholar. I will now turn to the full set of verses and share my own understanding of these verses, okay, which of course is informed by some of this work, but also my own reading of the Quran and what I have understood about the basic principles and values of the Quran. I'm going to share with you Dr. Mustafa Khattab's translation, which I've taken from Qur'an.com, simply because it is written in modern English, so it's easier to understand. You can choose to refer to the translations. And the translation I'm reading out is for verses 282 and 283 of Surah Al-Baqarah. Bismillahirrahmanirrahim. O believers, when you contract a loan for a fixed period of time, commit it to writing. Let the scribe maintain justice between the parties. The scribe should not refuse to write, as Allah has taught them to write. They will write what the debtor dictates, bearing Allah in mind and not defrauding the debt. If the debtor is incompetent, weak, or unable to dictate, let their guardian dictate for them with justice. Call upon 2 of your men to witness. If 2 men cannot be found, then 1 man and 2 women of your choice will witness. So if one of the women forgets, the other may remind her. The witnesses must not refuse when they are summoned. You must not be against writing contracts for a fixed period, whether the sum is small or great. This is more just for you in the sight of Allah and more convenient to establish evidence and remove doubts. However, if you conduct an immediate transaction among yourselves, then there is no need for you to record it, but call upon witnesses when a deal is finalized. Let no harm come to the scribe or witnesses. If you do, then you have gravely exceeded your limits. Be mindful of Allah, for Allah is the one who teaches you, and Allah has perfect knowledge of all things. If you are on a journey and a scribe cannot be found, then a security can be taken. If you trust one another, then there is no need for a security, but the debtor should honor this trust by repaying the debt. And let them fear Allah, their Lord, and do not conceal the testimony, for whoever conceals it, their hearts are indeed sinful, and Allah fully knows what you do. It's really interesting at the end of both of these verses, Allah reminds us that He has perfect knowledge of all things. So if a witness hides their testimony or alters their testimony or lies, then Allah knows. If a debtor does not dictate with truthfulness, then Allah knows. If a scribe writes something dodgy in the contract, then Allah knows. So whilst people might think they can escape by doing something fishy or fraudulent in this life, they will not be able to escape on the day of judgment. So in my view, then, after reading this set of verses, there are a few excellent recommendations in there. And I also want to remind everyone that the actual narrative starts from verse 275 onwards. So the first set of verses from 275 to 281 are about riba or usury and how to settle debts which have got riba in them. And then these 2 verses talk about debts more generally, okay? A debt or dain in Arabic refers to either a cash loan or it can refer to a sale where the payment is delayed. Okay, the dain is used for both of those, and this is the word used in the Quran is dain, okay, a debt contract. So here are the recommendations in this verse. First, write down a debt contract. So if there is a dispute in future, it can be resolved. We have to remember that Arabs did not used to write things down. They very much had that oral tradition. When they made a commitment, their verbal word was legally binding. But the Quran is gradually moving society to writing things down, so future disputes can be avoided. The second recommendation is to get 2 male witnesses. Now, on this basis, I've never come across ulama arguing that one man's intellect is deficient or a man has got, he's naqisul aql, and because his brain doesn't function very well, that's why you need 2 men. Nobody ever talks about that. But look how the Quran is mentioning this. The Quran starts by saying get 2 male witnesses, because actually, if men had such sound 100% perfect recall, then you would only need 1 witness. But the Quran is starting by saying get 2 male witnesses. Why? Because it's an established principle in law that human memory is usually not reliable, and human memory can only lead to probability of finding the truth, okay? Probability of establishing truth. So it is better to have corroborating witnesses. This is why all courts of law across the ages look for corroborating testimony. The Quran is giving the same principle and saying get 2 male witnesses. Then the Quran, using the guiding principle, also says choose 2 from among you. What this means is people who you know well, people who you know to be truthful, reliable, and who would act as who would have probity. So they would act as good witnesses to this contract, and it's the amount of debt which is being written down, when the debt is going to be settled, all of that is being written down. Now, in those days, it was mainly men who were engaged in commerce and finance. So this, as I said, this verse is about dain or credit. So women, because they were usually not involved, the Quran is simply suggesting more corroboration. Okay, so ask for two women to witness and corroborate should this go to dispute. So it's mainly men who are doing this financial dealing. But if you can't find a man, then just find two credible female witnesses. And if one of them forgets, the other can remind her, simply because women don't do this dealing very much. It really is referring to the, socioeconomic context, the socio-historical context in which the Quran is being revealed. Then the third recommendation is let the scribe write down faithfully. And then the fourth recommendation is let the debtor dictate. Again, very interesting. Why is the Quran saying let the debtor dictate? Because the debtor, the person who's taking the loan, is often the person of lesser financial means. And the Quran is actually empowering the slightly weaker party to have influence on how the contract is written. So the contract is written in proper, accurate, favorable terms. Now, this commitment of the Quran to justice and fairness is always so inspiring. And I find that in every Quranic law, in every Quranic recommendation, you will find this commitment to justice and fairness. It's just absolutely amazing. Now, the fifth recommendation is if someone is on a journey, then they are recommended to take a pledge or a security for the debt. If the two parties trust each other and know each other, they do not need to take a pledge. They can just choose to transact without a pledge. So these are really practical considerations about financial transactions which involve dain or credit, where a settlement will happen in future. It is not immediate. That is why all of these recommendations are being made. So there was never a formula in the Quran about halving the testimony of women or questioning their credibility. If anything, we find in Surah Nur, where there is a dispute between a husband and a wife, and the wife is accused of adultery, that it is the woman's testimony that has more value. So the Quran is not establishing a ratio at all. But what has happened is that over time, juristic concern about social movement of women, the reluctance to give women authority over men, tafsir interpretations of these verses, and male scholars' tendency to say negative things about female biology and psychology, they just accumulated over time and turned into this really simplistic saying that a woman's testimony is worth half or that it is worth less. What matters in a court of law is to secure justice for all parties. You will be astonished to hear that in England in 2017, there was a landmark case where the testimony of a 2-year-old child was held credible in a sexual offense case. Why? Because they spoke the truth. So the main consideration for a judge should be to establish the truth, not to get stuck with the question of gender or even age. And yet, what has happened is that this view that a woman's testimony is worth half of a man's, it is said repeatedly all the time in popular Muslim discourse. And as with so many other so-called religious truths about women, this is simply used to silence women and take away their political power and their voice. Unfortunately, I've heard people say things like, why should anyone take you seriously? You're a woman and your word is worthless anyway. So this is how it plays out in social settings. And it is a form of grave injustice. It disempowers women politically and socially. It is important that we inform ourselves and raise our voice against this injustice. If there is social pressure which is preventing a woman to give truthful testimony, then we should stand up against that social pressure, because it would mean that injustice would be done if she's prevented from giving truthful testimony. There is nothing in the Quran, there is nothing in the noble example of our Prophet which says that a woman's word is worthless, or that it is worth half of a man's word, or that she can't be given credibility. There is absolutely nothing in our sources, in our canonical sources, like that. It is only through this accumulation of opinion over a period of time that we've reached this point. I don't think I need to remind people that women are running countries, they're running banks, hospitals, courts, schools, they are lawyers, they are writing contracts all the time, witnessing them all the time. Silencing them by misusing the beautiful teachings of the Quran is no longer tenable. And I think women should develop the courage to question any demeaning interpretations about them. And if, as a woman, your circumstances don't allow you to do this because it can have serious repercussions for you, then at least try not to perpetuate these silencing mechanisms in your own homes. I hope that this video has been informative. I hope that it has given you a really good insight into how our mufassirin and our jurists have explained this verse, and how our jurists particularly have developed kind of understandings and interpretations from this verse and transferred them into kind of legal reasoning and procedural law in terms of women's access to court and women's ability to give testimony, and also women's right to act as judges in courts of law. We can see that women's ability to do that was curtailed through various reasons, sociological, biological, psychological. I hope this has been of benefit. If you are benefiting from my research and you feel that will be helpful for others as well, please subscribe to my channel and do share. Please also support my work by becoming a member of my channel. I've got 2 different membership options on my channel, and I would love for you to sign up to my newsletter at my website, sitaraakram.com. This is where I announce new courses as well as when they become online, when they're available online, so you're not missing out on the latest from me. Thank you as ever for listening to me. As I've always said, I am absolutely committed to the ideas of justice and egalitarianism and compassion. This is how I read the Quran. This is how I have understood the Quran. This is how I've understood the great example, the normative praxis, and the uswa, the beautiful, noble example of our Prophet Muhammad sallallahu alaihi wasallam. I find the message of the Quran and Sunnah to be empowering, to be uplifting. And I'm sharing all of this with you to give you insights into how we receive religious wisdom and knowledge, how we see these things as, kind of axiomatic, these truths. But often there's a lot of interpretation, accumulated knowledge and process of interpretation behind them. And the more insight we have into that, the more informed we are, and the more able we feel to challenge some of the demeaning and diminishing interpretations, particularly that we find about Muslim women. Thank you as ever for listening. Look after yourselves. Inshallah, I'll be back next week. Assalamu alaikum.